Major news out of Texas. A federal district court has just dismissed an indictment under a 1930 federal statute saying that it was unconstitutional in light of the Supreme Court's decision in Nysurpa versus Bruin and the Second Amendment. This is a critically important case because it shows yet again another federal judge in the United States that is willing to apply the Second Amendment as it is written and to apply it as it was understood and explained by the Supreme Court in Nysurpa versus Bruin. The more of these decisions we get in favor of the Second Amendment, in favor of individual rights, and against the government, the better it's going to be for all of us going forward. We'll talk more when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, best-selling author, constitutional attorney, member of the United States Supreme Court Bar, and yes, proud American gun owner. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms, and please join us and follow us on Twitter. Okay, folks, I have breaking news here. This is the name of the case. It's out of the Western District of Texas. It just came out about an hour or so ago. The name of the case is United States versus Gomez. This is a very big deal because it's another victory, and not just any victory, a huge victory for the Second Amendment, because this is a decision that is going to start to cut back on what I view, in my opinion, as in many instances, government overreach to try to deny people the right to keep and bear arms for reasons that, shall we say, haven't necessarily been proven fully in court. With that said, here's what happened in this case. The defendant named Jose Gomez Juarez was indicted for various felonies. And he failed to appear at certain hearings. And then the next thing that happened is he tried to buy a firearm, and he did take access to that firearm. But remember, he hadn't been convicted. He had only been indicted, right? There was no conviction yet. So he took possession of a firearm while there was a pending indictment, but not yet a conviction. In other words, he hadn't been found guilty. He hadn't been turned into a felon yet. Notwithstanding that, what happened was, during the pendency of this indictment, it's not clear whether or not he knew or not. It's unclear from the decision, but it doesn't appear relevant to the case decided by this judge. And by the way, the judge who decided this case in favor of the Second Amendment is Judge David Counts. He was nominated to the Supreme Court by President Donald Trump, and he's a graduate of the Texas Tech School of Law, I believe, down there in the Western District of Texas. So what Judge Counts decided was he looked at the history of the gun control, well, basically the Federal Firearms Act back in 1938, I believe. And what he said was he looked at the Supreme Court's decision in Bruin. He then concluded that obviously the text of the Second Amendment, the right of the people to keep and bear arms, applied here because contrary to what the government argued, this individual acquired a handgun, he acquired the firearm, and the government says that the Second Amendment does not apply to acquiring a gun or receiving the gun. Let me repeat how crazy that is. This is very important. The United States government took the position, according to this opinion, that you have a right to keep, which means to have, and a right to carry, which means to bear, which means to carry. So you have a right to have, you have the right to carry guns, but you do not have a constitutional right under the Second Amendment to receive guns. Well, the court here, Judge Counts, basically just laughed out loud in his opinion at that and said that is just simply absurd. The notion, how else are you going to get to keep a firearm if you cannot receive the firearm? It's analogous to saying you can have a firearm, but you can never receive a firearm under the Second Amendment. He said that's obviously silly and absurd and rejected the government's argument here. He then went on to say, and this I think is why it's so important to the Second Amendment, his approach, his methodology said that the 1930s is not a long-standing gun control law. He specifically said, and this is very good for us, he says, look, government, you can so first of all, he says that this law that restricts this individual's ability to have a firearm while he's under indictment, right? He hasn't been convicted yet. He's just been charged. He's been accused of something by the government. It seems like everyone's been accused by the government nowadays of something. Just the way it is. I mean, just turn on the TV. But set that issue aside. So this guy's been accused of a crime, hasn't been convicted, yet he takes possession of a handgun, and they charge him for having a gun while he's under indictment, which is a violation supposedly of 922N of the Gun Control Act of 1968. But the government then says, oh yeah, then he's convicted of that. So Mr. Gomez argues that, yeah, you've convicted me of possessing this handgun while I was under indictment, but it's an unconstitutional statute. And this is where Judge Counts says, yeah, it is, because it's up to the government, now that we've shown the Second Amendment is applied, and he said the Second Amendment applies because the right to keep and to bear arms includes the right to receive them in the first place. And because he received the gun, that's a constitutionally protected act in the normal sense under the Second Amendment, is what the judge found. So in light of the fact that the Second Amendment applies to this conduct of receiving, taking possession of the gun, the question then became, could the government somehow justify using tradition and historical gun regulations? Well, the government tried to say that these laws in 1930, what year was the NFA enacted, by the way? Well, that would be in the 1930s, 1932. Interesting. I digress. The point is that the federal judge here, Judge Count, said that the 1930s do not count as long-standing gun regulations or prohibitions in American life. You have to go back to when the Second Amendment was written, when it was drafted, when it was ratified, and what year was that? Well, if you've been watching this channel, you're the smartest person in the room, and you can tell me 1791. So Judge Counts goes back to 1791 and basically says that in 1791, is there any evidence that a person accused of a crime was denied the right to keep and bear arms under the Second Amendment or otherwise? And he says, no, there wasn't. In fact, if anything, he kind of points out that there's some religious discrimination going on in England, where the Protestants, when they took over England in 1689 or 1689, 1691, I forget which one it is, but you get the point. Late 1600s, they disarmed the Catholics, and obviously the judge said, well, the founding fathers weren't keen on discriminating against religion in the names of keeping and bearing arms, so he didn't find that as a relevant precedent. So then the judge goes on to talk about some other precedents, but the good news is that the judge made it very clear, and I think a lot of you guys who quote this at me in the comments are going to love this. Let me read a direct sentence from the judge's opinion. He says, quote, "The right to keep and bear arms shall not be infringed." Period, full quote. This is from a federal court today in Texas. I repeat, quote, "The right to keep and bear arms shall not be infringed." Period, full quote, from a federal judge. So the things that you guys put down in the comments, they do become reality sometimes, and that's great news. The critical time period is 1791. This is very important because there's a lot of gun control laws that the anti-gunners like to use as long-standing prohibitions or regulations on guns set in the 20th century, which includes, of course, 1932, the 1930s, and the like. Because remember, the Sullivan Law, which was just struck down by NYSERPA versus Bruin, the Sullivan Law was enacted by New York in 1911, which was 20 years before, for example, the NFA was enacted. And this judge says, look, the relevant time period is 1791. The government has to show that in 1791, there's an analogous gun control regulation or gun prohibition in 1791, our founding period, when the Second Amendment was ratified, to show that a modern day regulation applies. Now, there's some exceptions to that involving carriage, but we're not getting into that here because this was an absolute prohibition saying that if you were under indictment, you cannot possess a firearm, protect yourself. And the court here, Judge Count, said there's no basis for that in history. Again, he also goes on, and this is quite interesting, he cites to a series of sort of racist laws or racist laws that were applied in the South, with racial bias to prohibit certain people from having firearms, and he drew some analogies to that to say a lot of these gun control laws that the government cites to are really kind of racist in origin, and the Supreme Court doesn't find them persuasive, and neither do I. So the bottom line is this, we can do more about this case later, but I got to cut to the chase. Major victory in Texas. A federal court has thrown out an indictment of an individual who, while being accused of a crime by the government, at the same time took possession of a gun, and this court properly applied the relevant case law, the relevant law, by saying that the key time period is 1791. Because there's no analogous gun control law from 1791, this indictment was thrown out because the statute, which was the basis of the indictment, was unconstitutional. Now, I think this is massive news for the Second Amendment, not necessarily specific to these facts, but the fact that the methodology that this Judge Counts used and the legal and historical methodology that other federal judges are using all across the United States, including by Obama judges and by judges appointed by Joe Biden in places like Colorado, it shows that the work of the Second Amendment community, given and the Supreme Court in NYSERPA versus Bruin, is paying off huge dividends because, among other things, that balancing test of good, bad, public policy, what's good and bad public policy in terms of gun safety, is completely irrelevant to the Second Amendment going forward. This court reaffirmed that fact, and this is very good for us because, as you know, we don't want judges balance away our rights in the name of public safety that the government always makes up arguments and excuses for. The Supreme Court says you can't consider public safety when you apply the text of the Second Amendment. It's already been dealt with by the founders. Apply the Second Amendment as it's written. And here's another example today of a federal court doing exactly that. And that is fantastic news given the methodology that these courts, such as Judge Counts, is applying in America today. Okay, I hope you learned just a little bit something today. I'm sorry I'm talking fast. I got an interview coming up in a few minutes. I got to get through this fast because I got another interview for the media I got to deal with. So again, if you haven't subscribed, please do so, and we'll see you again here at the Four Boxes Diner. Talk to you soon.
Orders up. Table 2A.